Welcome to a quick patent discussion today between me and Adam Stevens. As I think you know, Adam's a patent attorney, 18 years at Kurt McConkie, I believe, before you came here. Was it 18, Adam?
Oh, I think 17, something like that. I don't know. I guess
Okay.
count my summers, maybe that gets to
I'm
18.
glad I'm rounding it up. That's good.
Yeah.
So today we're talking about recent cases that affect tech transfer, tech commercialization, tech entrepreneurs. And so what's been happening, the Supreme Court just closed their session, so that's why it was on our mind. I don't think we had a Supreme Court case that affects patent law necessarily, but what did we have, Adam?
Yeah, I mean, there are maybe some cases that have an ancillary effect. I think, the most recent one, the Loper Bright Enterprises case where the court overruled Chevron deference, that maybe it will have an impact on patent law, especially with respect to, the patent office is an agency, and they've got a lot of their rules and interpretations relating to patent law. Now, some people have said the Federal Circuit doesn't really grant a lot of deference to the patent office anyway, maybe unlike some other agencies out there. So that may not have too much effect, but it remains to be seen whether the overruling of Chevron deference out there may have some effect on patents and patent cases before the Patent and Trademark Office.
Okay, fantastic. So let's break that down for a second. I think I know the answer to this one, but what is Chevron deference in a nutshell?
Chevron deference in the past has basically been, hey, the Congress passes laws. They can't pass regulations to control everything. And so they leave it up to executive agencies, which are all the agencies in the federal government, to do some interpretation of those laws, the gaps, the ambiguities that there are in the law when they establish their regulations. And for quite a few years, Chevron deference has said, the courts are required to give a pretty high level of deference to those agencies' determinations of ambiguities around law. And
so if you're a court, there's some litigation over an agency regulation, and you would say, well, it's ambiguous what this language meant, or if it was consistent with the statute, but we're just going to assume agencies know what they're doing and trust them, right?
Yeah, so basically the review that went on is basically if the agency has a reasonable interpretation, then that interpretation was granted deference and allowed to stand. Now the court has said, no, that's subsuming the court's role under the Administrative Procedures Act to interpret the law. And so the courts will no longer grant deference to those agency regulations, interpretations around the ambiguities in the law.
There's really a separation of powers issue. The court interprets the law, not federal agencies, and here an executive agency is being given the right to interpret legislation.
Yeah,
so,
Chevron, they were, now they're not.
Yes, correct. So Chevron is over. And so what you're saying is, let's wait and see what getting rid of Chevron deference does for patent interpretation. Will it change the USPTO?
Yeah, there's a pending petition for certiorari, the Supreme Court, for a patent case where one of the questions presented is, should Chevron deference be overruled? That's obviously a moot question now, since Chevron deference has been overruled. But it just goes to show that, the Patent Office, it has its rules that it establishes to interpret patent law, and as it's examining patents, as it issuing patents and things like that. And some of the rules that it sets up, they fill in some of those ambiguities in the patent law. And the question now is going to be, will that change anything? Like I said, some of the commentators I've read have said, the Federal Circuit kind of has been not loath to grant a lot of deference to the Patent Office under a lot of these questions. So it may be relatively little effect in the patent side, where in some other areas of the law it might be a greater effect. But regardless, there will be even less reason for the Federal Circuit to defer to the Patent Office in its determination making. I think the big question that some people have is, will it have effect on actual decisions in examination cases, especially with respect to court, I just lost the name. But anyway, the trials that actually occur at the Patent Office when people are seeking to administratively review patents that have been issued, and now they're being sued for infringement, and they're attacking the patents collaterally before the Patent Office. Whether those decisions will...
Those interference actions, what do we call those?
Well, they used to be interference actions. That was patents that were pending. Inter partes review is the actions now that we're talking about.
Yeah, so inter partes review, there could be aspects of it you're saying that were based on agency interpretations of statutes, and so those could be open for challenge now that Chevron's done.
Yeah, those could be. That, again, remains to be seen what the effect will be in some of those things. At a minimum, some of the rules impacting inter partes review cases and who can review those, some of those rules that go on there will very much be subject to interpretation. And the question is whether that'll even affect maybe some decisions.
Okay.
It remains to be seen. Great.
So the opinion makes sense to me, separation of powers and so on. But now there's going to be a period here where there's confusion or at least uncertainty about certain interpretations have been made by agencies, right?
Yeah.
So, okay.
Very much.
Great. Well, what else is on your radar?
Another one is there is a case called Select LLC versus Vidal, and that's a question for the interaction between obviousness type double patenting and patent term adjustment that happens. So a certain number of patents, when you get in the patent office, there's delay. And anyone that's filed a patent application knows that you get in there and then you wait. And sometimes you file a response and then you wait. In one particularly bad case that I dealt with many years ago, we filed the patent application, we waited, got through the whole long process. We did an interview with the examiner. Things looked like it was moving toward allowance, and then suddenly everything went dead silence. And we was going, what's going on? And so we called up the office, and it turned out the examiner had passed away. And patent got assigned to a new examiner, and then sat in that new examiner's queue for over 2 years before being picked up again. And then the new examiner did a new examination and looked at it, but changed their mind with respect to the allowance of the case, where the other examiner had been ready to allow it, issued new rejections and everything else. Well, I mean, that's the typical expectation, is that patent should issue in, I think, something like 30 months. Well, law grants that if your patent examination, if you do a normal examination, takes longer than a certain amount of time, the patent office will grant you a term extension that extends, relative to the delay that happened at the patent office. So in that case, it would have been potentially years of additional life onto the end of a patent, which is potentially quite valuable. Obviousness type double patenting says, well, you shouldn't be able to get 2 patents on the same invention if one will extend the term of your patent longer than the 20 years that should be granted. And in the case of Select, what had happened was they had some patents that none of the patents had an obviousness type double patenting rejection made against them. So there weren't terminal disclaimers in those patents. Terminal disclaimers are a way that you can say, okay, we're going to treat these patents as being the same patent. We're going to keep them owned by the same party. And if we ever try to, that way it avoids issues of two people, different people trying to enforce the same types of patent issues against the same infringer. But what happened is they had some delays in some of those patents. And so they had, by law, a patent term added to those patent cases. Well, now in litigation, they've come in and said, no, these patents should have had a terminal disclaimer. There should have been obviousness type double patenting. And so your patent term should have expired at the 20 years that one of these earlier patents would have expired, and you shouldn't get this patent term extension to it. And
so what would be a typical valid double patenting claim? Is it that there's well, go ahead.
Well, so double patenting says your differences between the claims in one patent and your differences between the claim and the other patent are so minuscule that they really shouldn't be allowed to be in 2 separate patents.
But wouldn't you just, in a case like that, wouldn't you just say the one patent is prior art to the other one?
Well, it's not prior art because they're in the same family. So one is a continuation or a divisional of the other patent.
So you're just trying to get more life, and you're doing it with claims that are just barely different from the original claims.
Yeah. So typically, what happens is you try to you worry that, we've got these claims that are issued now or are issuing, and we say, but we want to make sure that we can cover variations, because what's going to happen is you get out there and your patent issues, and 6 months later, someone's trying to design around it. They're making minuscule changes, trying to say, now we don't infringe. And so you keep another application pending to cover those changes. You get those changes in the continuation application. They vary in the scope. You're trying to get different scopes. You might have broad claims in one patent and narrower claims in another, or you might have slight modifications to be able to cover changes in the market to cover in possible future infringers that are trying to design around your patent. And double patenting obviousness type double patenting issues with terminal disclaimers says, yeah, you can do that. We're going to give you patent coverage for that, but we're going to tie the lifetimes of those two patents together, so you can't divide ownership. They have to live the same length of time and die at the same length of time. The issue in this case was those types of rejections were never made. The patent office never said these are obviousness type double patenting issues. They're not so close as to be obvious. And so they didn't have those types of terminal disclaimers. And then now they got in litigation. The court said they should have been obviousness type. And because some have now lapsed because of their time, the other ones, even though they were granted patent term extension, shouldn't be allowed to, patent term adjustment should not be allowed to, you should not be allowed to continue to enforce these patents, even though you're in that adjusted term, because they should have had those problems. So it's an interesting little kind of nuance on things, but a lot of entrepreneurs, a lot of companies do have these multiple patents going on. They do sometimes have this issue of different terms because of patent term adjustment. And the question being presented to the Federal Circuit agreed with the district court, as I recall, or either way, the Federal Circuit said, yeah, the patent should no longer be valid. You can't enforce these extra years, whatever the extra time is. I don't know if it's 18 months or 2 years or whatever, against your accused infringer on these patents that are too old. And the question is, well, should we be able to still enforce these? Because this patent term adjustment is a law of Congress. If this is recognition that we should be able to enforce those.
Yeah, so help me out on why is the patent term extension the issue? Like, it seems to me either the claim should have been rejected or not, and the fact that it was extended doesn't seem super relevant to me. Why did the case turn on that?
Well, the claims were valid when they were issued.
Yeah.
The problem is that they're trying to sue for infringement that's happened in the past couple of years when the first patent has expired, but the second patent hasn't because of
so it was the second patent they were enforcing. Got it.
Yeah, they're enforcing the second patent. And the reason, I guess, one of the reasons why this is interesting is that there's a new rule proposed at the Patent and Trademark Office related to terminal disclaimers as well. And it's interesting because there's a lot of focus going on with this terminal disclaimer obviousness type double patenting, and the new rule that's been proposed by the Patent and Trademark Office that's open for comment still is that terminal disclaimers will now, under the new rule, would only be accepted if you also agree that when you tie it to that other patent, if any one claim of any one patent that's subject to the terminal of the other patents gets invalidated, then the whole patent that's tied to it with terminal disclaimer would also be invalid. It would no longer be enforceable, which is a huge change. And it's going to make it really, you're going to see a lot of people doing a lot of things if that goes into effect, which remains to be seen. There's been a lot of negative commentary about it. You'll see a lot of people doing everything they can to avoid double patenting rejections and not filing a terminal disclaimer anymore.
Okay. And so when you file a terminal disclaimer, typically, why do you do that?
So you get a double patenting one of these obviousness type double patenting rejections, and you can either change the claims so they're not or argue as to why they're not obviously the same, or when you're saying an obviousness type double patenting, you're saying that this claim is so close to the claim of your own issued patent. And again, it wouldn't be a prior art issue because they're all in the same family. They're continuations of one another. If you say, in the obvious type rejection says this claim is so close to be an obvious variant of the claim that's already issued in this other patent. So you can't have this claim without it being tied to this claim as if it were one patent. Now you're going to see people say, okay, I'm going to either argue that this is stronger, that this claim isn't part, so close to this one as to be, or they're going to change it so it's not so close to this other claim as to be tied, to be an obvious variant of it. And the reason that, what people don't realize is right now, roughly 18% of patents that are issued in recent years are issued with a terminal disclaimer. This is affecting nearly 20% of patents.
So what are you saying with terminal disclaimer?
So terminal disclaimer says, okay, when this patent dies, this patent will die also.
Okay.
And it's kind of an interesting thing because terminal disclaimers are kind of a relic of the old patent system, because the old patent system, before reforms that were over 20 years ago, said that the life of the patent was 14 years from the date of issuance, or 17. Anyway, it was based on issuance, not on the date of filing. And so we had cases where what people call submarine patents, where a patent was filed in 1970 something, issued in 1990 something, and still had the full length of its life available to it. Well, the changes in the law that got it in conformity with the rest of the world, so now it's 20 years from the date of filing. And so a terminal disclaimer, if you got a submarine patent that was filed in 1970 and a continuation that was filed in 1971, the first patent issued in 1982, and then the second patent's issued in 1996, but has a terminal disclaimer on it, well, its life now gets shortened from 17 years to 7 years to match up with it. That makes a big difference. For a patent that's filed in more recently, that difference is much less. The terminal disclaimer usually has an effect of only something like a year or two for patent term adjustments, or rare cases when a whole patent gets invalidated or found unenforceable or something. But that's it's kind of an odd area of the patent law, but it's important for patent holders to know about, so they know how long they can enforce things, and they are making decisions whether to enter into a terminal disclaimer or not. Especially with this new rule change, patents normally are evaluated on a claim-by-claim basis for invalidity, infringement, and unenforceability. And now this new terminal disclaimer rule would say, hey, I've got 3 patents that are all tied together with terminal disclaimers. If I sue you for one, and one of the claims gets knocked out as invalid for prior art issues, well, even if all the other claims of that patent are still valid, because only one was knocked out, these other 2 patents that I had that are terminal disclaimer with that, these are now unenforceable. I can no longer, under that rule, sue anybody for those. So that's a really, really, really big difference. And so I kind of doubt that will go into effect in the way that's currently proposed, but if it does, that's a really big difference. It'll see a huge change in practice. And if people are preparing to move forward, it won't affect existing patents, but it'll be a huge change in practice for those that have patents pending before the patent office right now.
So if you're being strategic, say you're an entrepreneur, you've licensed a technology from a tech transfer office, we just get these things launched. We file the patent and then we're selling them to someone else, maybe you're licensing them. So say you're now the tech entrepreneur in control. How does this potential rule change affect what you would do? Like, what's your thinking?
Well, one of the big things that you'll want to do is consider when you're filing the application. Sometimes you look at an application, you say, okay, you're going to file, like as a tech transfer office, we often file a provisional application and someone licenses it before the utility decision comes along. And then they're making the decision what should be in the utility patent. And the patent office in the United States, they have a claim structure where it says if you file 3 independent claims and 20 total claims, that's all covered by your basic filing fee. Anything else more than that, you're going to get extra costs. Well, one of the things that you can do is look at your application and say, we've got what we think are multiple inventions in here. And in fact, we think we have 5 or 6 inventions in here that we could claim. We could claim aspect A is one invention, aspect B, aspect A and B together is one invention, aspect C, et cetera, et cetera. Well, what happens in the patent office is when you file that, the patent office looks at those and says, okay, these claims do cover multiple inventions, and we're going to restrict you down to covering only certain of these inventions. The good of that is that those can each issue as individual patent applications, and the patent office can never again issue a double patenting rejection against those because they've already made a determination that they're different inventions. Well, what we might see what you might consider as an entrepreneur or someone that's looking for a patent is to say, okay, yeah, we're going to pay the extra money for multiple claims so that we can get the patent office to say, yes, you have multiple inventions that you can then pursue in all these different patent applications.
Yeah.
The other thing that you'll do, as what I talked about before, is that you'll really fight hard to avoid terminal disclaimers. So you'll look at filing amendments to the claims and arguing that it's not an obviousness type double patenting application or issue, whereas in the past you might have just filed the terminal disclaimer and accepted it. It's a more expensive route to go because then you're paying for attorney time and argument to fight that rejection, where before you pay the minimal terminal disclaimer fee and file the disclaimer and be done.
it's also a rule change that would increase the work for the USPTO, right? So,
Potentially, yeah, but it'll increase the fees for them. I mean, both of those methods will probably result in additional fees to the Patent and Trademark Office, as people are paying more fees for more claims, more fees for more patent applications that are restricted out. Because when you get a restriction requirement, you can only pursue one of those inventions. All the other inventions have to be pursued in individual applications, which incur additional filing fees, et cetera, et cetera. And so there might be reasons why they'll want to do that. Yeah.
hmm. Okay, well, great. Well, that's super interesting. What's the is there any other case on your mind?
Yeah, there's a few more. Let's see. One thing that is coming to mind for me is that we are seeing a lot more regularly enablement and written description type refusals at the examination stage. And there's been a case called In Re Pen dealing with enablement. And then there's also the USPTO has also done an appeals review panel decision that will be or has been captioned Ex parte Chamberlain, and that's dealing with the written description requirement. And those are things that in the past, they've kind of been almost secondary issues for a lot of people. Everyone focuses on the question of, is it new or non-obvious with prior art questions? And then with the Alice Court line of cases, dealing with Section 101 and the abstract idea questions, that became very important for the area that you do a lot of practice in with software, business method types of things. That became very big. And we're seeing, I think, more and more, especially in complex arts like chemistry and biology, we're seeing more and more of these written description and enablement questions.
And well, let me ask you, I think I know what enablement is. That's the idea that you have to disclose enough to enable someone skilled in the art to practice the technology, right?
That's correct.
Okay. So what kind of objection or rejection on enablement? I guess they would just say you haven't done that. You haven't revealed enough information.
Yeah, and the big question there becomes often with genus type claims, and it's both written description and enablement issues are dealing with genus type claims where you try to claim an invention very broadly. So you've got, for example, in this case, they're talking about long chain polymers that they're using in, I believe it's in, battery technology, something like that. And the claims that you want to claim it very broadly. Say you've got these long chain chemical polymers that are linked together, and then you have constituent things sticking out to the side. And as a patentee, you want to claim various variations on the things that stick out to the side. And so you say, okay, I'm going to claim this. I'm going to claim that as an R. Just that's a kind of the common chemical term that you use. R is this attachment that, and then you say in your description, okay, R could be this, it could be that, it could be this or the other, and each of those R things is typically a carbon molecule with other things, or atom with several other things attached to it. And
your concern is if you don't do that, someone else is going to come along, see your technology, make one change to it, and then be able to do the thing that you're doing.
Exactly. And so you claim it with that way, with just claiming an R, where when you say R can be a lot of different things. And a lot of times people do that and they claim a lot of different R's in the subclaims, and then they put it in the description. Well, what happens is in the enablement situation, you put in your main claim, you say, okay, I'm going to claim this molecule where R can be almost anything. And that's the case, situation in this In Re Pen. And he said R could be almost anything, and then the number of repeating units could be anything greater than 8. Well, the prior art, the biggest thing that had ever been out there was 8 in those number of units. No one had shown that they could make bigger things than that. Mm. And the problem for the applicant in this case is that he hadn't described how you get more than 8 in a lot of detail. And he hadn't described, he'd given one example of an R molecule, but not a lot of examples, and not how to pick which ones would work, which ones wouldn't work. So there's really not basically it leaves it up to a lot of experimentation to the reader to understand how you would do all of these things that are in this claim. That's the enablement problem, because you're leaving it up to a lot of trial and error for some. Then the whole purpose of patenting, in theory, is that you're advancing the arts by teaching other people how to make and use your invention, and in exchange, the government gives you a limited time monopoly on those things. Well, if an enablement issue says you're not teaching us how to do this, and so we shouldn't give you your monopoly.
Yeah.
And we're seeing this more and more, I think, in the chemical arts, particularly biological arts, because there's a lot of, I mean, when you're talking about things like modifications to antibodies and things that you're going to use to create disease or treat diseases, you have to teach what the actual modifications are, or what is encompassed by those, and how you get there. Otherwise, your broad claims are going to have a really hard time getting by.
Okay, so in the U.S. patenting system, how is a written description rejection different than a failure to disclose description?
So written description, failure to disclose are pretty much the same. Enablement is a little bit different. Enablement is failure to teach how to do it. Written description is failing to just write out what is actually, just physically have in the written description what's in the claims. So written description, you might, they can be very similar. But written description, for example, you might say the example I'm thinking of, the claim says a method for treating a human, comprising then a list of things, but it doesn't focus on what maladies it treats. It doesn't focus on some of the methods that the steps you actually have to do. It just says apply this antibody with a certain domain to people. And the number of examples in the specification is very low. Well, it might actually enable how to treat certain things. Like the description might just say how to treat diabetes, for example. I'm just picking one off the cuff. But it doesn't explain how to treat everything that might possibly be treated with this molecule that they're thinking about, even if it enables and it describes how to treat diabetes. Well, the problem is that the claim is drafted very broadly, just as a method how to treat using this specific antibody. And so they're kind of related, but it's just their written description. It's basically what it really comes down to is a lot of people are looking to try and get patent claims on very broad claims without putting a lot of examples in the written description. And I think the thing you need to be thinking about is, okay, what do I really want to cover, right? So if you're filing a provisional, or if you're an entrepreneur or someone else that's got your project that's going on, you're saying, okay, what do I really want to cover? And make sure that lots of examples are in the application for that thing, as well as what are the broader scopes of what I want to cover. And at a minimum, say, how can we determine and adjust this to get to these next steps? So you're thinking a little bit more about where do we go for next steps beyond just where are we now and what we're doing. But if we're trying to cover more than that, if we're trying to cover next steps, then make sure that you put into your application what you would have to do to get to those next steps. What are the examples? What are the steps to get there, so that you can then cover those in your applications?
Well, and help me think through this strategically. If I'm an entrepreneur, I'm filing a patent, and I get the enablement wrong, like I don't disclose enough to enable someone to practice the technology, isn't that just a drafting error on my part? It doesn't make strategic sense to me, because during the 20-year pendency of my patent, people are going to figure out the enablement part on their own, won't they? In most cases. So I'm actually not accomplishing something. It's just poor drafting, I think.
Well, it's poor drafting, and and I think that's the problem that most people have, is that the drafting part occurs once. A lot of people don't understand that your patent, you can't change your patent once you filed it, other than changing the scope of what your claims are. But you can only change the scope of your claims within what's disclosed in that original application. And so what I'm saying is, your entrepreneurs, your business people, your patent drafters, your patent attorneys, they have to take the time and unfortunately spend the money to do the drafting right in the first place, because otherwise you're out of luck and you're going to have a really hard time later on adding to all of that. Yeah. And there's always the argument that, hey, I didn't include this because this is already known in the art. We know how to do we know what diseases you can treat with X antibody. I didn't have to include that in there. That always cuts both ways, because then the question is, well, if it's already known how to do that, then why do we give you a patent for it?
Okay, that's great. Well, good. I know I've taken longer than I thought we would already, but is there any other burning patent issue that you saw in the cases?
I think there's others we can talk about maybe another time, but right off the top of my cuff, those were my first choices.
Okay, well, we'll see how those issues play out, but thanks for helping us understand. I appreciate it.
Thanks.